Well, good afternoon, everyone. We're going to give it a second and let people get get on the call and get joined in. But thanks for joining us for our February Ranching 101. We are excited to have you here. And while we're waiting just a minute, just a reminder that the Cattle Raisers Convention and Expo is March 22nd through the 23rd here in Fort Worth, Texas. And if you're interested in attending or would like more information, you can visit cattleraisers.convention.com and it'll have the schedule, how to register, and all of that information. But to kick things off today, I'd like to thank our friends and sponsors at Ag Trust for their continued support to Ranching 101. So please enjoy this brief video from them.
When your passion is agriculture and a rural way of life, you need a partner who understands. That partner is Ag Trust Farm Credit, formed from two trusted farm credit associations. Our mission is to provide personalized financing tailored for full and part-time farmers, ranchers, agribusinesses, and rural homeowners. And because we live in the communities we serve, Ag Trust Farm Credit is here to help you succeed.
So once again, I'd like to thank Ag Trust for their continued support and dedication to not only our members, but the continued education of producers across the state. Today, we are excited to have Joe Will Ross joining us with his extensive background in agriculture and as an attorney. He is the perfect person to join us today. And so, just some housekeeping rules. If you have questions throughout the presentation, please feel free to use the chat or Q&A feature. We are going to try to get to them all towards the end. And if we can write a response out during the presentation to answer your questions, I will for sure do that. If you have any questions regarding this or any education here at TSCRA, you can always email us at education@tscra.org. But without further ado, I'm going to turn it over to Joe Will. Thanks for joining us. And if you're ready to share your screen, we'll get it shared.
Let me go. Thank you, Tyler. Can you see that? All right. Thank you. Good afternoon, folks. My name is Joe Will Ross, as Tyler said. I live in San Angelo, practice here, been here about 20 years. I grew up in Sonora on the family ranch there, and we raised cattle and Angora goats. And then I ranched a little bit in the 90s, ran a wool house in Ozona down in Crockett County, and decided that before the banker decided I need to I like to say I voluntarily retired from ranching. Anyway, today I'm very thankful to be asked to speak about renewable energy leases. A little bit about my practice. I am a lawyer here in Angelo. I represent landowners primarily, or the vast majority of my time is representing landowners in eminent domain fights. I also do the occasional electric transmission line routing case before the Public Utility Commission of Texas. And then I also negotiate solar and wind leases for clients. And that's what we're here about today. So as we shift through, there's that. And I want to kind of give a background, if you will, about property rights in Texas. And I think that's an important thing that we start with that. One, and these are my opinions, things that I've learned through in my understanding of the law, but more importantly, they're my opinions. You'd think that Texas is a pro-private property rights state. Historic, and because we have an abundance. I mean, over 90% of the land within the border of Texas is private property, owned private property. That doesn't necessarily equate to being a pro-private property rights state. And I'm not trying to step on toes or anything like that. The cattle raisers, Texas Wildlife Association, the Farm Bureau have been the leading organizations to rectify some issues regarding private property rights in the state of Texas. But we'll go from there. Now, renewable energy leasing right now is not necessarily a favored business development tool within the state of Texas today. I want to say this: if a landowner is doing a lawful activity on his property, a neighbor can't tell him what to do. Now they can try to sue, they can do all kinds of things, and we'll get to some of those issues later. You know, wind leasing in Texas has been around since the late 1990s. Some of those wind farms that were put in place then have been decommissioned. And then I say why renewables may not be as favorable for business development in Texas is because in the last legislative session, one of our senators filed SB 624, and it failed in the House. But that bill wanted to make renewable companies go through a permitting process at the Public Utility Commission, similar to what we do with electric transmission line routing cases. It failed in the House. And that's all we'll say on that. And then moving on to, so who owns the wind and the sun? Well, there's no law, at least, you know, as stated by the Texas Supreme Court, that we don't know. We assume that the surface owner owns the wind and the sun on their within the four corners of their property. And, you know, there have been you know, whenever somebody sells their ranch or does this or that, like minerals, they may sever the wind rights that go with the surface and retain them. And with the hope that if wind development does come, that would be an income stream that they could produce. In reality, I don't know how much of that has really impacted anything. Unlike other states, there's no prohibition against wind or solar development. And, you know, that's the express law. Now we get to the implied rights that go with just by virtue of owning land. So there's little law related to wind and solar leases. We'll get into some case law here soon. Everything that we think we know about wind and solar leasing really kind of derives, or not really, it is derived from, you know, well over 120 years or so of oil and gas litigation and jurisprudence, and there's an abundance of that. And so even though we've had the wind industry in Texas since the late 1990s, you know, a little over 25 years, there's not a lot that is out there either legislatively via statute or through case law. And there is no case that I'm aware of that recognizes wind or solar as being dominant over the mineral estate or the surface. It's just part of the surface. And when you get into these deals, and whomever may come knocking at the door, whether it's a right-of-way agent, it's a, you know, a company man, or something that you may just get in the mail, these leases are much thicker than a sophisticated oil and gas lease. In my experience, with a lot of leasing, and certainly less in the, you know, it's less now, but, you know, earlier, you know, a few years ago, I could tell pretty quickly whether a prospective lessee, whether it's wind or solar, were serious based upon what was in the document. For example, in both deals, these wind farms, these solar farms are very expensive, extremely expensive to build. And so the renewable company goes and gets financing in the market. And there will be several pages of what we call mortgagee protection. That's to say, hey, if the company doesn't make its lease payment, then the landowner can't say, hey, you missed a payment, I'm kicking you off. They don't want that. It's too much money at stake. So that's something that I look at that I can quickly tell whether they're serious based upon how extensive that whole clause. It'll be several pages. I know there's a lot of misinformation about renewable leasing and everything in the state of Texas. Here are the two statutes that I'm aware of dealing with wind farms and solar farms, and they are the Chapter 301 and 302 of the Texas Utility Code, and they were enacted in 2019 and 2021, and they pretty much mimic each other, and that's a good thing. They require minimum standards for cleanup at the lease whenever it terminates, whether that's 20, 30, 50 years from now, whenever that may be. And they also require a pretty significant bond to be posted, and that's usually after 10 years or something, like sometime after that. But that's to ensure that there's available funds for the decommissioning of the solar farm or the wind farm. I remember one time I was told, trying to get a bond on a solar deal. Anyway, and I was worried about that. And so the opposing counsel, he said, Joel, there is a lot of copper in these solar panels and things like that. We're going to come get that. And so that was pretty good. But another thing that with solar panels, they're not so big that you can't go out there with your own cutting torch and mess around with it. I don't encourage that, but at least you can self-help if that ever happens. And I don't think it will, but I don't think you can get out there with your cutting torch and cut down a wind turbine tower at all. Most of us don't have that big enough equipment. And anyway, so if you do that with the Tyler, can you everybody hear me all right?
We can. I was just going to tell you, we had a question and I felt like it would be better to answer now than to answer at the end. It said, these statutes apply to leases created before 2019.
I believe they do, but I'm not sure. I'll have to I apologize. I don't know, but I know that I negotiated a wind deal in 2016. That law came in 19, and then we had an amendment to add the language from Chapter 301. So I would say probably yes, but I don't know for certain.
Perfect. Thank you.
What's interesting about that, the legislature, the state of Texas, decided when they recognized there were issues with leases, particularly the older leases that were put in the late 90s, and that was before I became a lawyer or started law school. So I can't speak to those old leases. But the legislature thought it was important to enact those two statutes to ensure that there's money for cleanup. Interesting, and by contract, it's my understanding there is no similar law requiring oil and gas companies to do the same. It's with case law. If you've got a sophisticated oil and gas lease that requires the operator to clean up its equipment on that pad side or whatever's there, then they have to do that. But or it's breach of contract. But if it's not in the plain language or a term within the oil and gas lease, there's no statute that I'm aware of that requires the companies to clean that up. There may be some federal stuff. I'm not sure, but not under Texas law. So we have very little litigation on wind farms. The first case that I'm aware of was this Rankin v. Florida Power and Light Energy back in 2008. Actually, the trial was in, I believe, December of 2005 or 2006. I can't remember. I attended the opening statements that on the day of that trial. NextEra Energy is the name of the company now. That case involved, it was in southern Taylor County around Coronado's camp. Neighbors they filed a lawsuit. The issue at trial was a noise nuisance case. Ended up that was the cause of action that was available to them. And the case does not speak on wind rights or anything like that. It was an expert witness disclosure case and the sufficiency of those disclosures. And so NextEra Energy won the case at trial. I think it was 11-1 jury verdict in favor of NextEra, or what is now known as NextEra. And then the issue on appeal was the noise issue and expert disclosure, and they won that one as well. The next case, I'm not real familiar with it other than that the neighbor lost on summary judgment for visual nuisance. Aesthetics, things like that, visual viewshed, have long been decided are not what we would call a compensable measure of damage in Texas. We see that in eminent domain cases, particularly with electric power lines. The next case was back in 21, where some neighbors sued the governmental entities claiming loss of value to the land. They lost because there was no standing. Now, solar opinions, probably the most important case, there's been 2 or 3 cases. This Lyle v. Midway Solar from out of the El Paso Court of Appeals. I think the opinion was issued either December 30th of 2020 or the 31st. Why is this important? Well, what you don't see there is the landowner's name. His name is Gary Durgoff, one of my clients. This was the lease that I negotiated in 2015 for my client. And it was really an oil and gas case. It was a case about who had control over the surface. Was it the mineral estate or was it the surface? And the plaintiffs they were mineral owners. They owned, some percentage of minerals under one river section in eastern Pecos County. And this river section extended northward up to the Pecos River. So this is south of McCamey, if y'all are familiar with this part of Texas. And anyway, I have to commend my co-counsel. All I did in this case was just carry a briefcase, and they did an excellent job of framing the issues and saying that this case was the accommodation doctrine applied. The specific facts were the mineral estate, they had no development plan for the minerals, they had no lease, there was no production. They attempted to change the well-established law, Texas oil and gas law, to make the mineral estate absolutely dominant over the surface. And that the court was not willing to, neither the trial court nor the El Paso Court of Appeals was willing to do that. So the mineral, through a series of motions for partial summary judgment, the mineral owner, they lost. And they also lost on appeal. There were two issues, whether the accommodation doctrine applied or was there a trespass. They claimed that both the solar company as well as my client, by entering into the lease, they trespassed upon the mineral estates, you know, their ownership right. And that was, the court decided, was not the case. It's to note that in this situation, Gary Durgach did not own, he only owned the surface. He owned no minerals. The one thing that the Court of Appeals did is that they dismissed the case without prejudice, meaning that the case could come back at a later time. And that was, you know, so we'll see what happens there. Another Court of El Paso Court of Appeals case, I believe this was out of Reeves County, and it was, again, a mineral versus surface, real similar set of facts, smaller tract of land, but the landowner represented himself, and he did not follow the case law that was established in Midway Solar, so he lost. And then last August, the Attorney General issued an opinion that county governments have no authority to bar solar farm development. To my knowledge, that's about it on case law in the state of Texas on renewables. So let's talk about wind leases and the key considerations. And there's a picture of what you know, a wind farm will look like. And let me say this before we get into this is, I think it's incumbent upon any landowner, when you've been approached about one of these projects, that you go hire, if once you make the decision whether you're going to go forward or not, you go hire an attorney that has done this, that is competent, is familiar with these deals. And there are a number of attorneys. This endeavor is not an inexpensive double negative there. It costs money to negotiate one of these deals. It just does. And it's not one of those things that you can go out there and say, hey, just look at this real quick and tell me if it's a good deal. No, that's just not how these things work. You just don't want to do it that way. So there are plenty of good attorneys that have done a number of these leases through the years, a lot more than me. But anyway, on the wind, and a lot of this will apply also to solar, is you have the development phase, and that's the option. So they'll pay you after you've negotiated, you got a deal, fully negotiated document, you're optioning your land, the right to, hey, we get to come in and do some studies and gather data, and you know, we get to decide whether we want. They're doing their due diligence, you know. So they'll erect a met tower to see what the wind may be. They'll study the transmission lines if they're close, do environmental, biological, soil data, all that kind of stuff. The option period is typically 3 to 5 years. Sometimes it may be an extra year. It just depends. The payment here is a small lump sum. It could be a small per acre, and that every operator does it differently. And, you know, that's a negotiation point there. And then once they do all their stuff and the project is a go, you know that the deal is going to make. And when I say going to make, it's going to go forward to where landowners can start making some money. That's when the construction phase. They've got all their data, they've got their financing, they've done their title work, and everything that they've got to do, they'll start working on construction. And that'll just depends on how big the thing is. When they start in the project, it's a 9 to 18 month process, and this is, you know, how the deal works. And then after the thing is built and the entire farm is built, then the operations phase, and that is when what they call the commercial operations date, and when they can sell wind that is in commercial quantities, not the test, not the whatever, it's commercial properties. And that may be a little later, but they, you know, the construction phase is a little shorter. And, you know, here I've got compensation is likely royalty based. Yes and no. Sometimes it can be a large minimum payment, annual payment. It can be, and just that's a lump sum payment. There can also be added on royalties above that, depending on how much the project is, and you want to tie it to the entire project, not what is just generated off your piece of property. Because not all, you know, that's the virtue of land. No piece of land, every piece of land is unique, and none of them are the same. From everything's different size wise. I've also seen deals where it's basically just a per acre lease, an annual per acre lease, and you negotiate that. And you know, moving on to the length of the lease, you know, some other friends that had gathered a lot of this data and shared it with me. Some of those leases lasted a long time with all the options. They, you know, 30 years, 25, 35 years is kind of the general term of the life of the lease. Now there may be a couple 5-year or 10-year, you know, 10 to 15-year option periods at the tail end, or it may terminate. This is when you want to say when the thing actually begins. It all depends upon when that commercial operations date is. The extensions, that adds time. You know, compensation, are there kickers? Is it tied to CPI, Consumer Price Index, or some other price indicator, or they're just a flat, what I call a kicker, every year, every 5 years, every 10 years, whatever that may be. And so it can be quite lucrative depending on how big your property is. So, you know, we'll see, but that's where having a good lawyer helps you. And I've kind of got into that a little bit. There are a whole host of fees or sources of income with these wind leases. There can be for surface site batch plants, which is a concrete plant. There's a lot of concrete that goes to hold one of those towers up. You know, the caliche pit, you know, whether they're hauling it in or you're selling it yourself. They have to crush that rock and things like that. You have the tower installation fee, and it's based off, for the most part, it's the nameplate megawatt fee. The nameplate is what the general megawatt capacity of that particular generator on that tower, or it may be a flat fee. There are fees for roads, electric lines, and other easements that within your property. It's important to note that when you get this lease, there are all these easements that you're granting to them. Some of them are non-obstruction easement. Well, what does that mean? Well, generally that is you can't erect something on your property that is over a certain height or allows anybody else to do that. And even if it's not on your property or outside what you've leased. So you have to be very mindful of that. There's gross revenue. Well, what does that mean? You don't, I mean, that can be watered down, and they're difficult calculations to understand. We lawyers are good at writing words. Hopefully we are, not necessarily. And there'll be run-on sentences upon run-on sentences to try to come up with this calculation. And that's the point of negotiation, is to what you say is to define what gross revenue is. One thing you need to do right up front, and the good companies will agree to this. They will. You want to ask for reimbursement of attorney's fees, and they'll do that. A good one will do that, and that's important. I mean, these are not inexpensive. I've said that twice, double negative. So let me say it again. Negotiating these deals is expensive. And why is that? Because there's just a lot of back and forth. It takes me at least 3 or 4 readings of the document to kind of have an understanding of what it is. And that's 2 to 3 hours, 4 hours of my time every reading. And whatever my rate may be, or any other lawyer's rate may be, that gets expensive real fast. I've seen fees that are reimbursed up to $5,000, up to $10,000, and that's in between those two numbers is probably a good starting spot as to what attorney fees very well could be. Anyway, that's that. So what's the impact? I mean, we've all driven down the road, and there are a lot of wind turbines in Texas. We've seen them all up on the I-20 corridor going east to west and around Sweetwater and Abilene, and then they're over there at Goldthwaite as well. There's one near Loma Alta in northern Val Verde County. There's a lot of leasing activity that's going on in Sutton and Slacker counties, southern Tom Green County at the moment. And anyway, there's a lot of activity. They're chasing federal dollars from the Inflation Reduction Act from a couple years ago. Anyway, these wind leases are big, multiple ranches, tens of thousands of acres, and maybe more. The scale of these things are getting bigger, and when you sign the deal, you won't know where a wind turbine will be placed. You just won't. That's what the testing is for, and that's their right to pick where they may be. You may want to reserve the right for them to cooperate with you and say not there. And it's best to put that language if you got a protected site, such as a family graveyard. You want to identify that up front. There are also roads that you want to say, no, you can't go there. Don't use that road. So I've had a client and a wind farm. We had it in the contracts. Don't use this road. No blasting. Lo and behold, that's what happened. So it was not real hard to negotiate a pretty big settlement for that mess up. And folks, make no difference. If you enter into one of these deals, expect to have gates left open, livestock to get mixed up. It doesn't matter if it's a wind deal, solar deal, less on the solar, but wind or oil and gas or anything other activity that you've got going on your property, gates get left open. And that's, you just, as simple it is to shut a gate. It just, they get left open. And the company knows that, landowners know that, we attorneys know that. It's frustrating. And anyway, there's some other comments there that I've already shed light on. You know, one little practice tip that actually a client taught me this in negotiating a pipeline deal was, hey, have a meeting, you know, before construction starts with the company man, with the construction supervisor, and just drive around the ranch, find out, say, listen, here's where the road where you're not supposed to go, do this and that. This is why it's important that we keep this gate closed or whatever. You want to put in there in the lease that they, you know, it's your request, put in cattle guards, because that'll help stop, you know, sheep and cattle. Doesn't, you know, you need a gate across that cattle guard, but it's just another security. They might not be willing to do that at the beginning of the lease, but we'll see, you know, or during construction. So all those things there. And I would encourage landowners to be involved with their attorney, to have more sets of eyes on a deal. Work with your neighbors if you know your neighbors are going to be entered into the same deal. I did a wind deal a few years ago, and 3 or 4 attorneys, you know, 100,000 acres of landowners, big ranching landowners, and we all missed, every single one of us, and both attorneys, co-counsel and me, we missed it too. And that was where we didn't have it in there that you couldn't bring on alcohol, illegal drugs, firearms, dogs, you know, and it's important, particularly down here where we are in more sheep and goat country, that the construction workers or the repair guys do not bring a dog onto your property. It just leads to trouble. So we missed it. We just, you know, I don't know what happened, but things like that happen. So it's real good to double check on that. Here, that first bullet point, you have to really study what the definition of wind energy is. There can be, and it's a long list, and it's probably 5 or 6 sentences about what that is. Could be. I mean, you have to be very careful to watch out for language such as energy storage facilities. That's a battery facility. You want that. That's a separate lease. If they're installing batteries, they need to do that at another time, and a separate set of money. I think it's a good idea to insert fines for misconduct in the lease, because if you don't do that at the beginning, it's very difficult to add it on in the negotiations later. You remember the very first bullet point I said is that as long as the landowner is as a landowner myself, if I'm doing something lawful on my property, my neighbor can't tell me what to do. But they can still sue you. You know, whether it'll stand up, you're being sued and have to spend the money to defend yourself. So it's very important. And most of the companies I've dealt with, I think everyone now, that the company indemnifies the landowner for third-party nuisance claims. If one of your neighbors who has not entered into the lease decides that they don't like what's going on over there, they sue you, in that. And so sometimes that's an open-ended a blanket defense. Other times there may be a cap on the amount of damages there. Also, and more recently, sophisticated leases, you want to reserve the subsurface pore space for carbon capture. It's not necessarily as you just want to make sure you don't grant it. You want to reserve it because you don't want any kind of a silence there. It's less of an issue from a surface use situation in wind deal versus solar, and we'll get to that a little bit later. Okay, so moving on into solar farm. This is an aerial of what a solar farm could look like on you. Some of these solar farms are over 4,000 acres now. Many are smaller. There's various different uses or whatever the end user may be. So the key difference between a wind and a solar farms is that the tower itself takes up a small area, and the wind company does not have exclusive use of the total leased acreage. They have exclusive use to develop the wind and all the other things that come with the lease. But in a solar lease, because those solar panels are low to the ground, they will fence, and it's completely covered in panels or however it is, like what you see there. It'll be fenced in, and it's an exclusive lease. So that means that you can't go in it. They're the only ones that can set foot in there. And that's a key difference. And that's why, if you do the compensation, we get a little bit later, where there's a pretty significant per acre lease rate, annual lease rate. So the other thing, and this was the issue that we had in the Midway Solar case, is who controls. I mean, if you're a landowner, in my opinion, if you're a landowner that owns 100% of the surface and 100% of the minerals, who's going to sue you from a mineral estate purpose? They won't. You hold 100%. That's rare in Texas. Many times the minerals have been severed from the surface long ago. And anyway, so you have to be careful there. If you're in a real hot oil and gas development area, I don't recommend a solar farm in that. It's just hard to work around. And as the courts have, oil and gas have kind of, the mineral state is dominant over the surface estate. It's not absolutely dominant, but it's still dominant, subject to the pre-existing uses of the surface. And then the burden, whenever the oil company comes and says, we want to put a pad here, we're going to do it here after you've got a lease, the burden shifts to the landowner to say, well, I've got a pre-existing surface use there that prohibits you. And so here's a reasonable alternative. And y'all hash it out. But when you own excess executive rights, for example, it was always recommended that, hey, if you're buying a ranch, buying a farm, you're buying half the minerals, but you buy 100% of the executive rights, the power to lease. Well, you've got to be very wary of that nowadays. That, hey, are you doing something? If you have 100% of the surface rights or the executive rights, are you doing something that could be infringe upon the non-participating royalty owners, interest owners' rights to get it? The oil lease comes around, so you have to be careful. On the lease length, it's 20 to 30 years. Like the wind, it's 2 or 3 phases: development, construction, and operations. And you look at it the same way as you do in a wind lease. The vast majority of these deals are on a per acre per year basis. And I like to say, through probably 9 or so years now of doing these deals, you know, $50 an acre to $850 an acre. Some I've heard a little bit more. You have to be wary of the flyer that you get in the mail that says, "Oh, we'll pay $1,200, but here's all these deals." And you know that if I just get a flyer or a little letter, 1-page letter, glossy printed letter, that goes in the trash. So, you know, topography is always an issue, both with wind and solar. How close are you to the big cities? You know, frankly, those of us out here in West Texas, we're not really growing in population. And all. So how do you know, what's the impact on current surface uses? It is an exclusive lease, as I talked a little earlier. That said, you may want to reserve, or I would encourage you to reserve the right to gray sheep or some other livestock underneath. Cattle really are probably too big, but you want to reserve the right to gray sheep under that. And so it's not a, we've done that in leases. Again, they'll come in there with bulldozers and they'll scrape it clean. Generally, they'll poison herbicides to kill the vegetation, whether it's mesquite country or greasewood country. You know, as we all know, that's if they don't do it right, it'll they'll come back with a vengeance. You know, one thing that you want to do with both wind and solar, are there going to be any change of use valuations on your property? And what that means is, can it be converted from ag recreation to commercial? And we all know if you lose your ag exemption, how much the taxes would be. And it's of great importance on these solar deals because it's a fenced in exclusive area. So it's incumbent upon and that the company reimburse you, pay all the property taxes for anything above what they are on the date of signing of the deal. And that's really important because you can be stuck with some rollback taxes and that can get pretty tough. Again, here it is real important that you reserve the subsurface pore space. You know, that is the injection, as I understand it, and I'm not up on this as well as maybe I should, but it's an injection of carbon dioxide down into a reservoir that's under your property. And that has to be, you have to have access to it as well as, you know, space for that site. And you want to reserve that stuff in the lease. Before we get there, again, on the solar deal is you do need to be wary of what the mineral interest clause, in my opinion, I look at the mineral interest clause. What are the duties that the surface owner have as far as getting surface, you know, accommodation from the other mineral owners? I try to kick that off to the company. That's what they're getting title insurance. They're doing an exhaustive mineral evaluation on the ranch, wherever it is. So I kick that off on them. Push as much as you can to the company to do, and they'll do it. But you need to do that up front. So some do's and don'ts. As I said earlier, you got to hire a competent lawyer. I know it just can be galling to pay for an attorney to do this. and because we are expensive. But hopefully, if you've negotiated things up front, you can be reimbursed most, if not all, of your attorney's fees. And the good companies, the good operators will do that. They recognize these are expenses. Negotiate. Everything is negotiable for the most part. And if, you know, as I've had some of my colleagues say this, and I like it, if they won't negotiate, tell them no. There is power in the word no. When you're negotiating, I've seen it time and time again. That's how you call a bluff. You just say, no, we're not going to do a deal if this clause is still in there. And the company will do the same thing. So, for example, a clause, it's a most favored nations clause. It says if you're one of the earlier ones and then later there's somebody else that signs a better deal, compensation wise, that you'll get it too. You know, you'll get the increase, the benefit of that later deal. The companies obviously don't want to enter into those clauses. It's a matter of negotiation. There's various ways to include it. Most of the time, many times it's not it ends up not being a clause in the deal. I encourage clients on anything. Don't be so eager to sign the first deal, first piece of paper you get. I encourage you to work with your neighbors, particularly, you know, the attitude that we're seeing now from landowners is, you know, their eyes in, you know, the beholder. If my neighbor's going to have the wind turbines and I have to look across the fence at them, I might as well be looking at them on my property too, and earning income. And that's kind of become the prevalent thought amongst landowners. There is opposition, and you know, if somebody doesn't want to do it, you can't force them to. It's an arm's length transaction. This isn't eminent domain. They can't force you to do a deal. And so work with your neighbors, and then ask questions. Ask them until you get an answer, and they'll be glad that you did. I should have said this at the beginning. We'll get here at the end. I'm not your lawyer. We're not. This is just for general information only. And we have not created an attorney-client relationship. So go hire your lawyer. I just can't say that enough. Do that. And I want to thank y'all. I want to thank the cattle raisers for inviting me to speak to everybody. I don't know how long I've gone, maybe too long, but anyway, thank y'all. Oh, last thing, go vote.
Well, thank you so much for your time. And yes, early voting started today. As a member, you should have gotten an email too with where you can find locations to vote in your area. So if you need to figure out where to go vote.
Let me see the Q&A.
Is there a list for folks that do solar leases?
No, not that I know of. I mean, Alan Price here in San Angelo has done a lot. Parks Brown in San Antonio with Arthur Oodle and Joseph Fitzsimmons law firm, and his team have done a lot. Rod Wetzel and his firm in Sweetwater have done an extensive number of solar and wind leases through the years. The next question on the helicopter use. I don't know how you address that. I think that's really more of an issue with the particular pilot, whether he's comfortable flying around the turbines or not. And what little I've heard, they're not going to be real interested about that. question on what are examples of actual dollars paid for options and leases. Unfortunately, I cannot answer that. Those terms are confidential, and there is a confidentiality clause in every lease, and so I'm not at liberty to discuss that. And I'll have to. I want to say it was. Who was my co-counsel on Lyle v. Midway? I'm drawing a blank, and I'm sorry, but sadly, he passed away from cancer while the appeal was sitting at the El Paso Court of Appeals. So he didn't live to see his victory, but they did an excellent job. If y'all give me time, I can figure that out later and get it to Tyler and Brent. Mr. Thomas, it says oil and gas plugging is protected by the Railroad Commission. Yes, operators do have to post a bond to ensure that there's some, but in my experience, that right now that is not sufficient to get the job done and get the, that bond can be extinguished with less than one plugging operation, from my understanding. But that's it as far as plugging goes. But that doesn't address cleaning up the tank batteries and the Christmas tree or the pump jack or anything like that. And it doesn't do anything with what we may see out that's going on out in, Pecos County, Crane County, near Imperial, with a lot of those wells that have been plugged but are now spewing water.
Perfect. Well, I think the last question was about attorneys, and we got to that. And so if you have any more questions or need anything from us, please feel free to shoot us an email at education@tscra.org. We'll be happy to get that answered. And thank you so much for joining us today and for your time.
Thank y'all. I enjoyed it.